So we are back in the thrall of family medical leave. I think Kurt and Damien are going to continue working on that cross-reference, and we can pick that back up another time. And would love to continue with the walkthrough.
Yeah. So I'll include that in the committee's amendment. Representative Taylor highlighted a couple of cross-references within the subchapter relating to unpaid leave that I had not changed. So I will make those corrections, and I'll consult with him just to make sure I haven't missed anything that he saw. Great. So I think we'll get them all. This is why the process is good. I encourage you to speak up if you see something that you think I missed, because this bill is what are we looking at? 49 pages. And I've read it and written it so many times at this point that I do miss things because my eyes just go past it. So please, if you see something, bring it up and mention it. There are no bad questions when you see something that doesn't make sense in a statute. So.
Sure. So on page 6C, this is on the domestic assault.
Yep.
Domestic violence. The employee is not the perpetrator or alleged perpetrator. So does this need to go to judiciary? I mean, are we finding that person guilty?
No, so that's why we say or alleged.
Or alleged, okay.
Yeah, so that was actually this is, without taking too long, last year we have a crime victims leave statute already. And Senator Benning had noticed over the summer that it said victim, meaning that the individual had already been gone through the court proceeding, and the whole idea was to leave time for an individual to go through a court proceeding. So we've started adding alleged victim or alleged perpetrator to everything to recognize that in our, as everyone who's watched Law and Order knows, in our system of justice, you are innocent until proven guilty. And so we add that in, and it's not going into the actual criminal proceeding part of this. It's just saying, if you're the perpetrator or alleged perpetrator, you don't qualify for this job protected leave. So other questions? Okay, so I just took you through the definitions a few minutes ago to give you a sense of what's changing. The big takeaways are we've expanded the definition of family member and we've added safe leave. And this would be effective this coming July 1. Section 2 is also effective this coming July 1. Most of what we're doing on page 6 and page 7 is we're striking out redundant language because we've already defined parental leave and family leave. And then we're providing here on line 6 that in addition to those leaves, which already give you 12 weeks in a 12-month period, you have an additional 12 weeks in a 12-month period for safe leave. So the general committee felt that it was important to provide an additional 12 weeks for safe leave only, so that, for example, if you just took your parental leave, you're not restricted to whatever leave you have left if you have an instance of domestic violence or something like that. But it's restricted to safe leave only. So you only qualify for those additional 12 weeks if you have a safe leave, domestic violence, sexual assault, or stalking incident that requires safe leave. You otherwise, that 12 weeks sits unused.
And how many weeks are we talking for?
So the combined total, if you took a parental or family leave to the max and a safe leave to the max, would be a maximum of 24 weeks. Parental and family leave, the max combined total for those is only 12 weeks, and safe leave is only 12 weeks. So you would have to have qualifying events for both in a year.
And again, we're still in the unpaid.
And this is unpaid leave.
This is labor law and not so much our.
Right.
Okay.
And then the other changes in here just to reflect that there's short-term disability insurance and other insurance benefits individuals can take advantage of. So it allows you to use either your accrued paid leave or insurance that your employer uses, which is the reality for employees these days. It just hasn't been reflected in the law. And then a lot of the other changes here are just technical and adding non-gendered references rather than gendered references. On page 8, again, just some cleanup here. The original law didn't deal with notice when it's an unanticipated leave, for example, a premature birth or an injury that you weren't expecting. And then updating to reflect the serious health.
I have a question about that one,
Yep.
Damian. So you, when you described it, used such as, but the statute doesn't use such as. It seems like a closed list, but maybe I'm reading it wrong.
Yeah, so unanticipated serious health condition, miscarriage, unanticipated need for safe leave, or a premature birth. Those were the ones that so unanticipated serious health condition or need
Separate from a miscarriage or separate. Okay, great.
Yeah.
Thanks.
So yeah, that's
Okay.
4 separate items that
Thank you.
the committee downstairs came up with where you might have the need for leave that you don't have advance notice of, like you might for a surgery or something like that. And then the B here deals with documentation for safe leave. So it provides different forms of documentation that an employee may provide if their employer requests documentation. Important thing is employer can request documentation. It's up to the employee to determine what documentation to provide from the allowed list. The reason for this is that particularly if it's intimate partner violence, there's often not a police report filed because of concerns about criminal charges against the partner. So in that case, it may be a priest or another religious person or a doctor, something like that, who files the affidavit or provides the statement. It's not necessarily an affidavit, just to be clear. I do want to note, so there is a self-certification option, and one thing that had been brought to our attention between when this passed out of the House General Committee and now is that the language we used here, similar to the domestic partner language, we used old language from a different statute, and on line 8 it references protected tenants, and there was suggested language from the Vermont network that reflects better what we're getting at, because this is from a housing statute and we're not so much concerned about protected tenants. And I'll bring that language to the committee when you start marking up the bill. And then C is just privacy. And this is, again, reflecting existing law. You can't release private medical information, and we don't want the release of private information relating to a safe leave unless disclosure is permitted by law and it's consented to or required pursuant to court order or law. And it's essentially repeating existing privacy law. And that is it until the bottom of page 10, where the General Committee removed the option for employees to waive their rights to unpaid leave or unpaid job protected leave. This isn't saying that the employee has to go back to their job. It's just saying that they can't agree at the time they need the leave to waive their rights to job protection. So that language is there. And then this last paragraph here relates to instances when the employer can claw back compensation that they pay to the employee during the leave. So this is an instance where the employee says, I'm planning to come back. The employer might pay them a bonus or some other form of compensation in anticipation of that. And then on the last week of their leave, the employee says, I'm not returning. the employer has the option of clawing back that money unless it was the employee's serious health condition that necessitated the leave, or it was a safe leave where the employee was the actual victim or alleged victim. And the reason those two are accepted is those are instances where it's conceivable that the employee may not be able to return. Maybe they didn't recover enough from their injury or illness, or maybe they've had to move away entirely or seek a different job for their safety. But the other instances, it does allow the employer the option. The employer can waive the right to claw back that compensation. And this doesn't include accrued vacation or something that the employee leaves. This includes other compensation the employer pays.
Could you say that last sentence one more time? Okay.
Yeah, so if you have accrued vacation or sick leave and you use it for your unpaid leave here to provide some wage replacement, your employer can't claw that back. But if they provide you other compensation, and this is read narrowly to be compensation, so not necessarily the health insurance split that we're talking about, but we're thinking things like bonuses, commissions, other things that you might get paid during the leave in anticipation of you returning to work that you are not otherwise entitled to. The employer is allowed to claw those back from you after the leave if you don't return. So if they've held your job open and you don't return and it's your personal decision not to return, your employer can say, well, I paid you that bonus because I was expecting you to come back. I'm gonna seek to have it repaid. So this doesn't get into how the employer would do that. It just provides the right. The employer could claim a debt and then, go through a legal process to claim it if the employee wasn't willing to give it back.
Representative Andrews and the representatives.
And we're still talking about unpaid leave, so we're not talking, they can't claw back regular wages because there's no regular wages.
Right, exactly.
Thank you.
Yeah.
Did you discuss disability income insurance?
So they did, this isn't compensation that the employer paid to or on behalf of the employee during the leave. So an insurance policy is going to be separate from that. Yeah. So, and yeah, it's important to the on behalf of could include like tuition benefits that the employer pays as part of their compensation package. If they provide tuition benefits for the employee or a family member, they could seek to get that back. Okay, so that's the changes now. The next two sections are set to change when paid leave goes active, so when people can start using benefits. The important changes there are pretty brief. Biggest one is that employer goes from those previous cutoffs of 10 or 15 employees. So I'm on page 11, I'm sorry. So right now, current law, if you're under 10 or 15 employees, you're not covered by this law, depending on which provision's being invoked. Beginning on October 1, 2026, under House General's version, if you employ anyone in Vermont, one or more individuals, you're covered. And you may have to provide job protected leave.
And that's the same date as the time where the insurance program goes into effect.
That's right. That's when employees could start taking benefits under the House General proposal.
Does this include agricultural workers?
It does not restrict employer. So there is, with the job protection, there are a couple caveats that are important to note. So if the employee had given notice or they had been given notice that their job would end during the period of the leave, they're not entitled to job protection. So for example, if you're hired on a 1-month contract by a farm and you get injured during that contract and you take this leave, you're not entitled to your job back in 3 months when the farm has finished its harvest and has no need for employees and wouldn't have had you on staff anyway. The other two things that are covered are if the employee would have been laid off or their position discontinued during the time of the leave for a reason other than the leave. So for example, a manufacturing employer misses out on a contract they were anticipating and has to lay off a shift at the plant. That's not covered. You're not entitled to job protection if your shift would have been laid off or the plant would have closed down. And then the third one is, I have to look back at this.
Economic injury.
Oh, the employee performed unique services and hiring a permanent replacement was the only option open to the employer to prevent substantial and grievous economic injury. The important thing there is that they have to give notice to the employee ahead of time and say, you're irreplaceable, or, we can't hire a temp to replace you. We have to hire a permanent replacement.
Okay.
And so we want you to know that before you take the leave, we can't keep your job open. And so that's the third option there. And these are all a continuation of existing law. But it would now apply to smaller employers.
So does that also mean, some families contract with a company to come mow the lawn once every 2 weeks, or a housekeeper who comes to clean the house once every week or every 2 or 3 weeks? Does it include those people?
Those people would be independent contractors. So they run their own businesses. So the housekeeper doesn't just keep your house. These days, they would, have multiple clients and be running their own business. Same thing with the landscapers, gardeners. There are any number of people who come to perform services at your house are typically independent contractors. It's very rare that people have a household staff these days where that individual is their employee. The exception would be things like nannies and au pairs, where they're hired on a long-term contract and they have a full-time job with the family. In that case, you may have to hold the nanny's job open. But it depends on the contract. Again, if the contract says you've got a job for 3 months or it's month to month, then there's no guarantee and the job could discontinue at that point. So, okay, so that's the first big change that's going to happen on October 1st. The second one, this language here
On
page 12, the middle of the page, lines it up with anyone who is qualified for benefits under the paid leave program qualifies for job protection. The reason why we set this out separately from the job protection, the other job protection language, which we're keeping, is if you're a multi-state employer and someone transfers, or if you're one of the many employers who are now letting people work remotely in Vermont, and your employee moves up here and then they haven't been paying into the program long enough to qualify for benefits, but they've been employed by you long enough to qualify for job protection, that employee still gets job protection. The flip side is, though, you may have Vermont employees who have qualified for benefits, but wouldn't have qualified under the previous job protection. And so we're entitling both to job protection. Essentially think of it as casting a net as anyone who's qualified for benefits or would have previously qualified for job protection qualifies for job protection under the new version here. Okay. And then the other change is that parental leave and this goes back several versions of the paid leave bills dating back to previous sessions. Parental leave was eliminated as a term and it's just all grouped under family leave. And that was kept by the general committee. It's really just a terminology change that requires a number of small tweaks, some of which I think Representative Taylor identified that I had missed. So it's not a necessary change. It was just a terminology change. And then everything else is just renumbering. And then when you get to the leave statute, the only really substantial changes here are to add the provision that you can use family and medical leave insurance benefits as wage replacement. That takes you through the employment laws, which gives you the background, sort of the basis for the program now. So the way to think of it is the employment laws are the job protection. The rest of this bill relates to the insurance benefits provided by the state or the requirement that employers provide benefits if they decide not to participate in the state program.
And to put it in ways and means language, the rest of the bill impacts the revenue of the state.
Bingo. That's exactly right. So it is, the rest of the bill deals with the money. So from the state's perspective. So it creates a new chapter in Title 21. It creates a new division of family and medical leave in the Office of the Treasurer. And the division would have a director who's a full-time state employee. They'd be an exempt employee serving at the pleasure of the treasurer. They are not subject to approval by the Senate or anything like that. They serve at the pleasure of the treasurer. And they're responsible for operating and running the division. It's important to note that this is the language that enables the treasurer to appoint that individual, but we do need language in the bill to authorize the positions. That language is not in the bill currently because the treasurer's office is still working on a projection of how many positions they would need for the department or the new division there.
Damon, before you go through in detail, can you give us the equivalent of a section by section, and then we can come back and go detail section by section?
In
Thanks.
fact, I have a section by section.
Oh,
Let me pull that up.
can you send it to Sorsha too?
I will.
Not have to do it right now. It can
Get to it.
after, yeah.
So. So just forgive the section by section. It goes a little bit deeper than you might like in spots, but I'll try to go high level through it. So this is as recommended by House General. If we go to starting in section 5. So the first section in the new subchapter creates the division and establishes the director. The second section creates the actual program and establishes a special fund for the program, which would consist of the contributions collected. That's another word for payroll tax. And then the fund can be spent on benefits and costs of administering the program. There is some, Emily Byrne at JFO had a look at the special fund language and has some suggested tweaks that either this committee or appropriations will likely want to consider. And I can bring those when we start doing markup. The contribution rates, the initial rate is set at 0.55%. For employees, that's a 50-50 employer-employee split. Employees cannot be required to pay more than half or 0.275%. For self-employed individuals who decide to enroll in the program, so it's opt-in for self-employed, it's a full 0.55%, same as if you pay self-employment taxes instead of FICA.
And so there's the structural question that Damien's going to take us through. The actual numbers will likely change, and we're going to hear from JFO tomorrow.
Right.
So that percentage will likely change, and any other numbers in the bill will likely change based on updates we'll hear from JFO tomorrow.
Yep, and this language is going to need an update too, because in getting it out of House General, I forgot to take the 0.55% out of statute and put it in the session law as an initial rate. That is then followed up, as you can see in the second bullet here, or the second dark bullet, it's the rate is updated annually by the division. And it's determined based on projected benefits and administration costs plus a 75% of expected benefits reserve.
And again, that reserve percentage is something that we're also able to change, and we'll have conversations with JFO about that tomorrow.
Yeah. The contributions are paid to the Department of Taxes in the same way as income tax withholding on wages or quarterly payments on self-employment income. Importantly, for self-employed individuals, currently you would make estimated payments based on last year's liability or your expected liability this year. If you choose to enroll in the program, you're going to have to document your quarterly income because that's part of how benefits are calculated. There is some discussion too, and this is something you'll want to talk to taxes about, is right now for individual employees, they don't actually figure out the withholding attributable to an individual employee until W-2s are filed. So on a quarterly basis, you're getting a lump sum from employers, and then at the end of the year, they give you W-2s that break that out by employee. So currently, benefits are based off of 2 of your last 4 calendar quarters, but additional documentation needs to happen if you do that, or you have to look back at the prior tax year.
And that's something JFL will bring to us tomorrow.
Yep. Employers can opt out of withholding and paying contributions by providing a private plan. And we'll talk about that in a little bit, but the employers are not required to participate in the state plan if they have an employer benefit plan that provides the same or better benefits. Benefits are up to 12 weeks of benefits in a 12-month period. You can use 12 weeks for family or safe leave combined. So this is different than job protection, where it's 12 for family leave, including parental, and then an additional 12 if you need safe leave. In this case, it's 12 combined. And it's not that you can't take the additional 12 weeks of job protected leave, you just aren't going to get wage replacement through the state insurance program. And then there is also 2 out of the 12 weeks could be used for bereavement leave, which importantly includes both bereavement following the death of a family member, but also administering or settling their estate. And the administering or settling the estate can extend into out years. The wage replacement is 100% of the employee's weekly wages up to the state average weekly wage. Currently, that's $11.35 a week. JFO is going to talk to you a little bit more about wage replacement and taxes because of,
Talk to us about it tomorrow. Yeah.
various issues.
100% is likely needing to change as well.
Yep. Benefits are paid in increments of a day. This recognizes that for certain serious health conditions, you don't need a block of 6 or 12 weeks of leave. You might need a block of leave and then periodic follow-ups for treatment. And so that's consistent with existing family leave law. And then benefits can be used as wage replacement. And that's just clarifying again that these serve as wage replacement for the family leave laws. Eligibility is limited to employees or self-enrolled individuals who made contributions in 2 of the last 4 calendar quarters. There's no minimum contribution amount. You just have to have paid in 2 of the last 4 calendar quarters. This could change depending on how you set up the wage tracking. And then you have to be unable to work due to a serious health condition, caring for a family member with a serious health condition, pregnancy, recovery from birth or miscarriage, caring for a newborn, newly adopted child, or newly placed foster child within a year after the birth, adoption, or placement, safe leave, or bereavement leave. It's important to note that there is, in the language, there are references in the bill to qualifying exigency, which relates to the deployment or other issues related to deployment for an active duty member of the armed forces. And that was inadvertently left out of this eligibility list, even though it's mentioned elsewhere in the bill. So that's.
So it's just not in the section by section.
It's not in the section by section because it was inadvertently left out of the text of the amendment.
Oh, okay.
Yeah. So that's something that you will likely want to add in.
And Damon, you have a running list of sort of things you've caught since this.
I do. I have
Kurt caught and things that.
I have a running draft of technical amendments.
Great.
For the committee to just.
Thank you.
Yeah, it's getting longer every day, unfortunately.
We're happy to be here for that.
But yeah, I've been drafting the language as it comes up. So, and then you're not receiving disqualifying income. Disqualifying income is any week you're receiving unemployment insurance or workers' comp related to the injury or where you're totally unable to work, or any day where you're receiving wages or paid leave, accrued paid leave from your employer. So like sick leave or vacation leave. The idea is to prevent people from somehow gaming the system to increase their benefits. The application is designed to be fairly straightforward with necessary documentation of the need for leave. And then it can be submitted by the employee or the enrolled self-employed individual or their agent if they're unable to submit the application. And then it has to be reviewed and ruled on within 5 business days. But if there's additional documentation needed, and this commonly happens in the employer context when you're dealing with a parental or family leave, there's a 15 business days additional that can be added to allow time for the individual to get that documentation. And you can submit 60 days before or 60 days after the start of the leave. Again, this takes into account if you have an unexpected leave and you're otherwise occupied, it gives you up to 60 days to get your application in for backdated benefits. Payment of benefits. Benefits are payable from the day the leave started. Payments begin within 14 days after the start of the leave or the approval of the application, whichever is later. Benefits cannot be garnished except for unpaid child support, unpaid state taxes, or to recover overpaid benefits from a prior claim. So in other words, if there was an issue with a prior claim and you received $500 too much, the state can withhold that money from your future claim. And benefits are subject to income tax withholding. When Abby comes in, she can talk to you a little bit more about the income tax ramifications. We've been looking at that and it's complicated. In most cases, it's subject to income tax.
You mentioned that only the garnishing would only be applicable to state income tax.
Right. So we don't control federal income tax. They can seek repayment of that through their own mechanisms.
Can we wait for clarifying questions till we actually get into the language of the bill? I just wanted us to have a big picture before we dove into the language, but I think it's easier to ask clarifying questions when we're in the language because then we can maybe even answer our own questions.
All right. So 2058 allows an individual who's self-employed to opt into the program. Initial enrollment has to be for a 3-year period. This is to prevent people from jumping on when they need the leave and then jumping back off. And then it's year to year after the first 3 years. You have to agree to provide documentation of your income so that they can verify your benefits. And you can be covered both as an employee and self-enrolled individual or self-employed individual. The benefit of that is basically if you earn most of your income as a self-employed individual or a substantial portion of it, you can boost your weekly benefits. It's entirely optional though. Employers have the option to comply with the program by a private plan. So really important to note, employer benefit plans are generally covered under federal law. So we can't dictate how they set up their benefit plans unless the benefit plan is exclusively designed to qualify or to address the requirements of this law. But if it's a combined benefit plan, we can't control that. All we can do is approve the benefit plan as complying with the requirements of this law. So basically an employer could say, I've got this plan that's got short-term disability. It provides leave for all the things that are required under state law with wage replacement that's equal to or better than that, covers all the same employees, covers all the same conditions. doesn't disqualify anyone for reasons that they wouldn't be disqualified under state law. And if that's the case, the division simply says, check, you qualified, you don't have to do withholding for payroll taxes this year. So it gives employers the option of seeking a private plan. 11 out of 14 states that have paid leave allow employers to have this option. I have no idea what the uptake is like. I imagine larger employers do it more than smaller employers would, just because their insurance pool is bigger and they can probably get a better rate, but I don't have any data to back that up. Employers can opt in or out at the beginning of each calendar year, so it's a calendar year by calendar year thing. Disputes regarding coverage are appealable to the division, so that's an important note. It's like workers' comp, where if you have a dispute over whether you should be covered for a workers' comp injury, it goes to the Department of Labor. In this case, the dispute would go to the division. So the division would need to have some sort of adjudicator on staff to review these disputes and determine whether the individual is covered. The approval of the plan can be terminated if it fails to comply with the requirements of the law. So that would be like if the employer's plan was consistently denying people for a condition that they should be covered for. And if that happens, the employees would immediately shift on to the state plan as if they'd been on the state plan all along. And so they'd be treated the same as if they'd been enrolled in the state plan. And the employer would begin withholding contributions. Appeals, the basic piece with appeals is if you disagree with the division's decision regarding your benefits or the amount that you're required to withhold and contribute to the program, you have 30 days to appeal. If you disagree with the decision on the appeal, you have 30 days to file an appeal with the Supreme Court, which reviews it on the law. Basically, they take the facts that were before the department or the division, and they say, did the division apply the law correctly? 2061 deals with fraud. An individual who fraudulently commits fraud to either obtain benefits or avoid paying contributions can be barred from receiving benefits for 1 to 3 years. An employer that commits fraud to avoid paying contributions can be fined up to $5,000 in addition to having to repay the unpaid amounts. And this is in addition to the recovery of overpaid benefits. So basically, if you get paid too much on your benefits, the division can try to recover those benefits. The exceptions are, so first, repayment shall be waived if it was either the division's mistake or an unintentional error of a third party. And then requiring the repayments would be against equity and good conscience. So that's a judgment call for the director of the division. This is language taken from sort of standard language regarding repayment waivers and unemployment insurance. Important to note for those of you who have dealt with this with your constituents, this is language Vermont currently does not have, but is recommended by the U.S. Department of Labor. So.
And recommended in numerous unemployment bills that have floated around.
So it's being discussed, and this language was taken from the recommendations of your own unemployment insurance study committee from a couple of years ago regarding potential revisions to Vermont's law. And then an individual has a right to an appeal, and they can also request in the future that the director reduce or waive the overpayment for good cause. So that's a second chance for an individual to say, for example, if their circumstances have changed and they're now the sole breadwinner for their family and they become injured and the director says, well, you've got $2,000 you owe the department. They could say, my family is going to lose their house if you take that money away now. Can you reduce or waive the overpayment? And then the director for good cause could do that. So again, that's case by case, but it allows people a second chance to ask for a reduction or waiver. 2063 is standard rulemaking language. 2064 requires confidentiality because we're going to be dealing with sensitive health records and also potentially sensitive records relating to domestic violence or sexual assault. So all of that information is confidential and exempt from the Public Records Act. Only individuals and their employers can be provided with information as necessary to allow them to exercise their rights. So in other words, an individual may be allowed, for example, say you submitted your only copy of a form to the department. The department could provide you with access to that sensitive healthcare information to enable you to further pursue your rights to benefits. Disqualifications, I already talked about these. It's basically preventing collecting workers' comp and these benefits at the same time, or unemployment or wages. And then protection from retaliation or interference. This is a standard anti-retaliation language that protects employees from retaliation for exercising their rights or attempting to exercise their rights under the program. It prohibits interference with the right to seek benefits, and it prohibits employers from disciplining employees for taking leave that they receive benefits for. This really gets to attendance policies. So employers are allowed to have attendance policies, but you can't provide that protected leave for a serious health condition or pregnancy is something that's going to be negatively impact an employee under an attendance policy.
And when you say standard language,
So
we already have similar language to this.
Standard language.
Okay.
the last one here, the attendance policy language is new. But the first two, it's standard anti-retaliation language. And then the private right of action is created here for someone who's retaliated against. And it's based on the language we have in our anti-discrimination statutes, where it allows an employee who was retaliated against to seek lost wages, reinstatement, an injunction against the retaliation, things like that. But it does require them to bring the case in court if they want to do that. So the notice provision is the standard post notice in a prominent place in your place of work. So these are the posters you see in a break room. It also requires employers to provide a copy to new employees. This is something that we're starting to include in the employment laws because so many employees don't work in the standard workplace anymore. 2068, this is based on language from the sick leave law. It basically says that you can't use this law as an excuse to get out of an existing collective bargaining agreement or employment contract or policy that you have. And you also can't use a collective bargaining agreement, employer policy, or contract to skirt the law. And then it references the job protection provisions, and then provides identical job protection language for the bereavement leave, because that's not covered under the existing laws. This would be a new type of leave at that time. And then the definitions are in section 2069. The important ones for your purposes are the average weekly earnings, because that may change depending on how you structure the bill and what information you want to use to track those earnings. And then the qualifying exigency language is there. Section 6 is going to be important for you because it allows the Commissioner of Taxes to share income tax information for purposes of the program. Section 7 requires rules to be adopted by April 1, 2025, which is 3 months in advance of tax withholding starting. Section 8 requires education and outreach materials for employees and employers by 30 days before income tax withholding starts. Section 9 is placeholder language for advance payments of state contributions to provide startup money for the program. The $20 million is just a placeholder, and that's going to be contingent on JFO's information and information from the Treasurer's office and the tax department. Likely what you'll see is separate appropriations for tax and the new division. And then that'll all be transferred into the special fund.
The $20 million, what years is it appropriated from, and where does that money come from?
That's all gonna change from what's in the bill anyway, based on what JFO is gonna say tomorrow, so I don't know if it's
Yeah.
trying to understand it now.
Okay. The Section 10 requires a report on the adequacy of the reserves in the fund in 2026, 27, 28, and 29. Importantly, the 2026 report is before anyone takes benefits. And that's basically to allow the new division to come in and say, we think that the amount of reserves you're requiring us to hold is too much, too little, just right. And just do a temperature check when you've got the staff coming into place. And then 27, you'll have 3 months benefit experience. 28 and 29, you'll actually have a couple of years of benefit experience. And then Section 11 allows for the initial approval of private plans, so employers can opt out from day one. The big things with this is it exempts employers from paying contributions during 2026. It requires them to start providing benefits on or before October 1 of that year. And then it requires a refund of any contributions paid in 2025. This language will also likely require some additional work from this committee just to govern how that refund is processed. And then the effective dates, the main piece here is taxes start July 1, 2025. Benefits are available October 1, 2026. There's a 15-month delay in there to build up the state's trust fund. Depending on how you structure it, that period can shorten, lengthen, and those dates can change. So, and that was, the general committee just left that so that this committee could do its work.
Thank you, General Committee.
Yeah.
Representative Beck.
In section 11, Damien,
Mhm.
if an employer decides to go that private route, first question is, can they or can't they use the plan that's the VSCA is taking advantage of, the governor?
That is the sort of plan that anticipates. So if the Hartford continued offering private plans in the state past October 1, 2026, this would allow an employer to sign up for a private plan with the Hartford, provided it met the minimum requirements of the statute. So it would be 12 weeks of leave, whatever wage replacement you settle on, same coverage. So it would be broader than the current governor's plan. But as long as it met that, they could do it through the Hartford, they could do it through MetLife, they could do it through any insurance company that's licensed or approved to operate in the state that provides that.
Okay. And second question, same topic. If an employer decided to do that, do they have to pay for at least half of the premium?
So the only thing that this requires is that they can't charge the employees any more than the employees would be charged under the state plan.
Okay.
So they can figure it out internally. So if they can get a better deal on the private insurance, they could do the private insurance and then just figure out what to charge the employees right up to that cap that's set in the law.
Okay. Thank you.
And are you done with the section by section?
I am.
Okay, so let us take a 5-minute break for stretching, and then we will attempt to finish going through the language with a full walkthrough. I think that's probably unlikely that we will do that, but that's the goal. And then we can get sort of the specific in the weeds questions answered. Yes,
Can I make one comment?
yes, please.
This is going back to the $20 million.
Will you identify yourself again? Because we're like in a new cycle of.
Robin Chestnut.
Thank you.
Ackerman, General in-house. The $20 million placeholder that was referenced earlier is an advance, designed to be an advance payment of contributions for state employees. So that amount, whatever it is, would be deducted from future contributions from state employees. So it's not a grant, it's an advance payment that would be repaid through reduced contribution payments.
And JFO will take us through
Yes.
all of that tomorrow.
That just didn't get mentioned, and I wanted to
Thank you.
make the distinction between a grant versus something that would be repaid.
We will talk about all of it
Okay.
tomorrow with JFO.